Okay, we are recording. And I am Joan Van Beesler, and I am the Director of Unitarian Universalist Justice, Ohio. And I am really pleased to see you all here tonight when we're going to be talking about bail bond reform in a time of pandemic, COVID-19, and all of the despair and the tragedy that's going on around us with our incarcerated sisters and brothers. Before I turn it over to Melekte and our presenters, I'd like to start us with just a minute of centering, if I could ask you to be with me in spirit, because as our state continues to grapple with the fallout of the coronavirus, our incarcerated sisters and brothers continue to suffer and die. And we want to remember those who have died or are ill from the COVID-19 in Marion and Pickaway and Franklin Medical and Elkton and other places of incarceration here in Ohio. We want to pause now in a silent witness to remember those who have died and raise our spirit and our prayers to support those who are now fighting for their very lives. Please join me in a moment of silence. May all be healthy. May all be whole. Thank you. So tonight we have a wonderful panel of folk. We have Melekte Melaku, we have Eileen McCully, we have Dave and Marva Patterson, we have Alex Chavers and Alana Garret-Ferguson. And these are all part of the ACLU of Ohio bail reform movement. And Melekte, who will be leading this discussion, is an organizing strategist for the Northern Ohio region. And Eileen and Dave and Marva and Alex and Alana, who you all have already met, are activists and leaders for the Cuyahoga County movement. And I will now turn it over to Melekte, and I will continue to try and get us on Facebook as well.
Thank you so much. And again, thank you for extending this invitation to do this. A couple housekeeping items. So on the second link that I shared, there's a volunteer sign-up form. So if you just copy and paste the URL, I'm going to put in the chat one more time, into the URL box, you're able to get to a Google form where you can put in your name, some contact information, and just give us an opportunity to contact you directly about the campaigns. So I'm sure a lot of you are already on the larger statewide ACLU email, but we're creating a list of bail reform movement folks, and we want to make sure that everyone can get involved. I also want to make sure I'm able to get this presentation in your email inboxes and have you see this material long after this webinar is done. So I am about to share my screen. Give me one moment. Okay, let's get this mouse away. All right, so we're going to be discussing bail reform and COVID-19. So this pandemic, this global pandemic, has exposed the weaknesses within our public healthcare systems, within our public education systems, but most critically, all of the conditional issues with our jails and prisons. So when all of these issues are exposed, it gives us an opportunity to restructure and organize to change the status quo. So we're going to be discussing bail reform, just some of the basics, the mechanics of it, the policy platform that we're trying to advocate, and give you an opportunity to organize after this moment, either regionally or if you want to participate and just stay on course with how the campaign has been moving. But everything that we're going to be speaking about is through the lens of COVID-19 and how we need to move after this moment. So I'm briefly going to cover our social responsibility for folks who are in our jails and prisons right now, give some general state updates and what the ACLU has been doing, what other advocacy groups have been doing in coalition with us, and talk about some messaging. I know this group has already been doing race equity work, studying mass incarceration work, so a lot of this messaging won't be entirely new, but I think it's important that we start to speak using the same language and have a shared dialogue around what is this new normal that we're calling for, and how do we advance all of the reforms that we're in some ways are seeing on the bail reform front right now. So it's our responsibility. There are 50,000 people in Ohio's prisons and jails. 15,000. Governor DeWine has done very little to release or call for reprieve, which would pardon, commute, or transport folks from facilities that are deeply infected to facilities that are safer. And he needs to take immediate steps to create a comprehensive, science-based action plan that will save the lives of folks within these facilities. And when we're going to talk about this later, but our reliance on the cash bail system is the leading cause of mass incarceration within this state. So when we address bail reform now and also address it later and create a new status quo, a new mandate for bail reform statewide and hopefully nationwide as this movement continues to grow, situations like these hopefully can be avoided or diverted in the future. So looking statewide, we've been calling for DeWine to release folks, but again, we have 50,000 folks in these facilities. What would release recommendations look like? So we want folks to be released who have any kind of underlying health vulnerability. We also know that folks incarcerated, 40% of them have chronic health conditions already. So this accounts for a large number of those individuals already. Folks who are over 60, folks with 6 months or less on their sentence, folks who are serving time for technical violations, which account for almost a quarter of folks who are in prison right now, maybe not calling your probation officer, maybe not being able to check in on time or get a job. So those are things that are putting people back into prison right now. Nonviolent offenders and people in prison for felony 4 and 5, which is the lowest level felony. So when we take all of these individuals, crunch the maths, our policy folks have said this would move a large number of those folks within prisons and jails out into the community where they can safely socially distance, which is completely impossible within a confined space. So let's talk about our targets and what we've been calling for thus far. So Governor DeWine has broad executive authority to call for mass release through a mechanism of reprieve. So reprieve would mean he could commute sentences, he could pardon them, he could move folks from one facility to potentially a safer lower level facility, and he has the full authority to do so. So the stakeholder letters that we've been releasing, a lot of the calls on social media, this is why we're calling for Governor DeWine to use his executive power to get these folks out and to not jeopardize the health, well-being, and safety of not only the individuals within, but everybody who is going in and out of those facilities, like the guards, just staff in general, and the counties that those facilities are housed in. We're also looking at Dr. Amy Acton. She has broad executive authority to call mass release on public health grounds. And then we're also looking at our county executives like sheriffs, county administrators, mayors. And this photo is Cuyahoga County Administrative Judge Sheehan in the middle, and then our county executive, Armin Budish. We want to bring up county executives in this moment because jails are actually operated by your local county or district. So a lot of the decreases that we're seeing, like in Cuyahoga County or Portage County or Licking County in their jail populations, that's because those officials, those stakeholders have made decisions and have implemented some aspects of bail reform to not have folks newly admitted or release folks who were there simply because they couldn't afford their cash bail. Quick update on what the ACL has been doing on the legal front. Full disclosure, I'm not a lawyer, but if you click on any of the links within this presentation, it'll send you to the press release and some more information about things that we actually filed. I'm just going to give a very, very brief overview. So the ACLU of Ohio and the Ohio Justice and Policy Center, Cincinnati-based justice and advocacy organization, they filed a habeas petition, which is a petition saying that this kind of detention is unlawful against the Federal Bureau of Prisons and the Elkston Federal Facility. So we were seeking release of those who are medically vulnerable, and on April 22nd, that release was granted. ordering 800 prisoner cases to be reviewed and then provisions to be made later. So who's medically vulnerable? Some of the folks that I mentioned before, folks with chronic health conditions, folks over a certain age, and there are a whole list of subcategories that we listed within that suit. So I strongly encourage folks who are curious to click on the link after this presentation is done and look at that amazing victory, because it was such a feat, and it just gave us so much hope within this moment that litigation can win in this moment. We also had a big victory filing on behalf of immigrants detained in the Geauga and Seneca County facilities. Sorry. And we, up to now, we've released 8 individuals through those legal filings. And I wanted to lift up an amazing protest that was coordinated by the Ohio Organizing Collaborative. They got over 100 cars to honk and protest DRC and Governor DeWine, and demand that 20,000 prisoners need to be released by May to slow the spread of COVID-19. So what's our messaging moving forward? Ohio jails and prisons are at 127% capacity. Decarceration needs to be the new normal. And how do we do this? Bail is the front door of mass incarceration. Bail, cash bail, is one of the leading drivers of hyper-incarceration in Ohio. And so when we say that we need to change the systems and we need to adjust the status quo or completely reinvent the status quo as we know it, we have to look at decarceration. We also need to embrace pretrial reform and cite and release policies. Again, just reiterating the fact that jails and prisons are not the answer. It's not the one size fits all. Something our lobbyist said earlier this week is that we know that there are a large number of folks who are in prison and jails because they're severely mentally ill. We know that there are a large number of folks in Ohio who are in prisons and jails because they're in the throes of their own addiction. And there are a large number of folks who are in those jails because they simply cannot afford cash bail. So it's just important to remember that these policies are life-saving now, and they will be life-saving after this pandemic ends. So before I get into the teaching outline, just reiterate the point that decarceration needs to be what we lead with moving forward from this moment. And we have a huge opportunity to remake the cash bail system. We have a huge opportunity to point out our over-reliance on the cash bail system. And remember that bail is truly the front door. So if we want to dismantle mass incarceration as we know it, we have to pull the foundations apart. That's what bail reform truly is. And so I'm going to transition and let my volunteer leader, Eileen, take it from here.
Hi, everybody. I'm so glad that you're all here with us tonight. Thanks for being interested in this issue. I'm going to start talking about the fundamentals of bail reform. COVID-19 aside, bail has been a problem for a long time, and misuse and abuse of bail procedures have been responsible for a great deal of unjust incarceration and untold collateral damage since long before COVID-19. So first, I'm going to set the scene for you and name some of the actors so you can understand how this system works or doesn't work. When a person is arrested, they generally make their first appearance in a municipal court in the jurisdiction where they're charged. In the Ohio Criminal Code, all the criminal acts are divided into felonies and misdemeanors, and each of those categories has 5 subcategories. So if the charge is a misdemeanor, the court, the municipal court is usually the place where the entire case plays out. It never leaves municipal court. If the charge is a felony, it gets bound over to the Court of Common Pleas. Now, municipal courts and the Common Pleas Court coordinate to some extent, but there's really a lot of variety in the ways that municipal courts operate, so procedures can be really different depending on the jurisdiction. Both municipal court judges and Common Pleas Court judges conduct bail hearings in their respective courtrooms. And then for those cases that are bound over from uni courts to Common Pleas courts, those judges in Common Pleas have the opportunity to review bail settlements. When it comes to prosecution, city solicitors are the prosecutors of misdemeanor crimes within city limits. All other misdemeanor crimes and felony crimes are handled by the county prosecutor. Both city solicitors and county prosecutors can make bail recommendations, and they each have an enormous amount of discretion over which crimes will be charged and how aggressively. And that makes them really important targets for when we're talking about bail reform. The sheriff, excuse me, the sheriff is the head of the county's law enforcement and runs the jail. The funds to run the jail are taxpayer funds, and those are managed by county government. Depending on what county you're in, that's either a county council or county commissioner. So these are all the people most involved in bail and in pretrial detention: common pleas and muni court judges, county prosecutors, city solicitors, the sheriffs, and county council members or commissioners. So it is kind of complicated, and there's a lot of moving parts, but there's really only one thing you need to know to get started. There are people in jail because they're poor. Now, that might be hard to believe. It certainly isn't what we're taught in school when we learn about the justice system. So I'm going to walk you through it and try and illustrate how that works. So when you're charged with a crime, you know that you have certain rights, like a jury of your peers, the defense of a competent attorney, and that you're presumed innocent until you receive a trial and a verdict. These are protections that our country is renowned for, and we're rightly very proud of them. But the thing is, the trial doesn't happen right away. There's a delay between the time you are charged and the date of your trial. We call that the pretrial period. Very clever, I know. It could be days or months, and it can change depending on factors outside your control. What happens to you in the meantime? That's where bail comes in. So what is bail? I think Melekte has, oh, there we go. What is bail? Bail is the cash, bond, or property the court requires before they're willing to release you during the pretrial period. The court wants assurances that you're not going to skip out on your trial. Someone like a judge or sometimes a magistrate will decide on the conditions of your release, often guided by a bond schedule. The bond schedule assigns different dollar amounts to different criminal activities, different offenses. So if you pay cash bail, you can get your money back when you show up for trial. If you can't come up with the cash, you can sign a contract with a bondsman, usually at 10% down. And in that case, when you show up for your trial, you can't get your 10% back, but you can get the, you'll keep whatever collateral you use to secure the bond. So what happens when you can't make bail? You end up in the county jail until you go to trial. We call that pretrial detention. Someone else charged with the same crime who can afford to pay their bail will be released, but you have to go to the jailhouse. Clearly, this is a two-tiered system based on wealth, and it's unjust. No money, you're stuck in jail. Money to pay, you get to go free until your trial date. Not only do you lose your liberty if you can't pay bail, but there are many additional consequences to being held pre-trial, and we'll get to those in a minute. But first, I'd like to describe some of the ways that bail is misused and abused. Bail exists to facilitate the release of people while they await trial. It's not supposed to be used to detain people, but it often is used that way. Across Ohio, judges use bail as punishment, as a debt collection device, and to signal falsely to the public that they value public safety. Prosecutors use bail to extract plea deals. People who are desperate to get out are far more susceptible to making a deal than people who are at liberty. These abuses of the bail system contribute directly to mass incarceration and to overcrowding. Take a look at this slide. These are national numbers from the Pretrial Justice Institute. For every 100 people charged, 34 are detained because they can't afford bail. So in most county jails, more than half the population is in pretrial detention. So our jails are full of people who haven't been convicted of anything. When we look at the explosive growth in jail populations over the last 20 years, and there has been explosive growth, 95% of that growth comes from non-convicted people. So before I turn it over to others to describe some of the consequences, the downstream collateral damage from pretrial detention, I want to clarify something that most people are confused about, or at least I was confused about it before I got involved in this issue. Jails are different from prisons. Jails are run by counties or cities. There are no rehabilitation services, no programs, no libraries, and it's strictly a place to lock people up. A prison is a state or a federal facility full of people who've been sentenced to relatively long terms, a year or more. The formerly incarcerated people that I've spoken to tell me that prison is an awful place to be, but it's nothing compared to county jail. County jail is truly horrible and dangerous. A U.S. Marshal's report on the county jail here in Cuyahoga County described the conditions there as inhumane. And we're not just talking about unpleasantness. 8 people died there in the course of a year. It's unsafe. Basic medical needs go unattended. Mental health, we know, is a primary issue for a wide swath of the incarcerated population, but there are no mental health treatments. People can't meet with their lawyers when staffing shortages lead to lockdowns. And remember, more than half of those people are there not because they're guilty, but because they're poor. Okay.
Well, I wanted to, oh, sorry.
Go ahead.
I just wanted to make sure that the audience was able to see this slide. So let's conceptualize the Cuyahoga County Jail. There's usually about 2,000 people who are in the jail at any given time. So you have 2,000 people, 6 out of every 10 of those individuals are held because they're in that pretrial stage. They've not been formally convicted of a crime. They're there literally just being held in that space. 5 out of 6 of those are there because they cannot afford bail. 5 out of the 6. And so when we talk about this exploding pretrial population, we have to conceptualize it as in, this is half of the people in this jail at any given time. Half of these individuals have not been formally convicted of a crime. And we're going to talk a little bit more about some of the collateral consequences and the risk of what happens when you're being held pretrial and the disparate judicial impacts that you experience. But this is huge. And when you begin to multiply the numbers, that's 19,000 people in Ohio who are being held, again, they've not been formally convicted of a crime. And then when we look outward, that's 500,000 people. So I really just want to, underline Eileen's point about the explosion of pretrial growth and even break it down more with this chart. If you're starting from an area that's overly policed, a Black area, you may be targeted. You're more likely to have an encounter with an officer that escalates. And from there, because we understand the dimensions of race and class and that socio-historical structure, from there, we know that people of color are going to be less likely to actually afford that bail amount that's assigned to them, and they're more likely to get a bail amount that's actually higher. So that we see this process criminalizing poverty at every single step.
Are we ready?
All right, yeah.
Okay, thanks. Hi, I'm Dave Patterson. This is my wife, Marva, and we're going to talk a little bit about pretrial detention. An April 19th, 2018 document submitted by the Sentencing Project to the United Nations was entitled Report to the United Nations on Racial Disparities in the U.S. Criminal Justice System. Now, this document describes, among other things, the adverse elements of pretrial detention. The report showed that African Americans were incarcerated in local jails at a rate 3.5 times higher than that of non-Hispanic whites. That's a really key component to make sure that we ingest. This brief also showed that 65% of those in jail back in 2016 were being detained pre-trial, and it also informed us that they not only had an increased chance of conviction, but they also succumbed to unfavorable plea deals and much harsher sentences. That is also key. What is often not divulged is that we have judges who do not set bail according to a defendant's ability to pay. That is also key. And that also contributes greatly to the overwhelming numbers within our jails. Also, in the first 30 to 90 days of pretrial detention, Blacks and the poor overwhelmingly tend to lose jobs, residences, transportation, and in some cases, even their children. Some of these people are detained 8 to 10 months and even a year or more in overcrowded, unsanitary conditions, which are presently made exceedingly worse given COVID-19 and this pandemic and the problematic issues that it provides. These people cannot social distance, and their lives are actually at risk. So at this time, what I'd like to do is pass the baton to Marva, who's going to discuss an actual case study within Cuyahoga County, and she's also going to brief you on some of the components of the Brady Doctrine. Marva?
Yes, thanks, Dave. And I'm glad to be here today in order to pass on this information. I have been a Christian community activist for over 20 years and a person with nerve and mobility issues caused by a car accident through no fault of my own that changed my life. Therefore, I can personally understand the difficulties individuals can have navigating a harsh judicial system that lacks the ability to adjust to a defendant's medical issues, especially if you have illnesses, mobility, or language barriers that may require medications or special accommodations. These individuals may lack the capabilities to process instructions quickly, which can be viewed as intentional by a law enforcement officer or a judge when they can't follow directions and comply. This can lead to abuse. The jails are overcrowded and inept at caring for those with medical or mental disabilities. When we examine the judicial system and the disparities against people of color, it is very obvious there is a long-awaited need for criminal justice reform. In order to develop reform and find solutions, we must take a deep dive into the causes, examine the reasons why people of color are so vastly marginalized. Far too long, the obvious flaws in our judicial system has gone unchecked. This is not mere coincidence or just someone rattling on about injustice without reason. We have obvious legal discrepancies intentionally unchecked or investigated, primarily against those who can least afford proper legal counsel. This is a price one pays for being poor and of color. In some cases, we have seen a judicial system rely on information known to be false against a defendant. This defendant could very well end up being charged and incarcerated in direct violation of the Brady Doctrine, a pretrial discovery rule that guides the prosecution in its evidence gathering. If we had a fair legal system in place, a defendant in this instance would therefore be found not guilty and released. Instead, they add to the massive jail population. We would also not see the many wrongful convictions evidenced by the many cases filed against the city and paid out through many lawsuits. The current judicial system we find ourselves relegated to costs litigants unreasonable expenses and heartache when left unchallenged. Many will lose their jobs, housing, and possibly their children. They will be saddled with unprecedented costs when jurisprudence is not upheld by a system that's designed to marginalize people of color, such as in the case of Robert Starks III, who was Black. He was arrested and incarcerated for 30 days for a crime he did not commit. He was arrested after a warrant was issued on a 10-year-old rape and kidnapping case. He was indicted by the grand jury, The grand jury returned a true bill, meaning the evidence was sufficient to support the crime. And even though the person who filed the charges made it clear the perpetrator was white and known to her, Mr. Starks was indicted. Mr. Starks lost his job, his place of residence, and nearly lost his children. These are situations people of color find themselves in, shackled to a system that chooses not to admit when they are wrong. Instead, they incarcerate you or keep you coming back for pre-trials, of which we have seen as many as 45 to 50 in a single case, hoping to bully you into taking a plea deal for a crime you may be innocent of. Our judges are the rule makers who adjudicate cases before them. They have discretions to rule fairly based on the evidence and our constitutional rights to due process. We need smart justice in order to fairly move forward if in fact reducing the jail population is our goal. So
Marva, before we move forward on the next slide, can you walk us back a little bit to discuss the consequences of pretrial detention? Why is it that if someone is being held during this period, they're more likely to get a conviction and get an even longer conviction? Just, take it back a bit so we can all level.
Well, many individuals, once you're incarcerated, it's very hard to understand how the system really works. And many are incarcerated and in jail can't afford to bond out once those bonds are set. And those that may or may not know of individuals that are incarcerated, they have a tendency, they're sitting there. And not only are they sitting there for inordinate amounts of time, it's hard on them. They may not have the proper attorneys, or maybe even attorneys.
You may not have an attorney at all.
Right, not at all. We've seen that also. And if in fact you are able to bond out and come back for these pretrials, it's a constant ongoing of one pretrial after another, when a pretrial is supposedly set to determine whether or not the charges levied against you have evidence supported, are properly before the court. So these are a lot of those consequences. And in the meantime, you're afraid. These people are scared. They're afraid they're going to lose their jobs. How many employers will allow you 10 or 15 times constantly, miss work and constantly having to return to court? Eventually, you will take a plea, even though you're innocent.
Yeah, and then there's another dynamic too, and this isn't often considered. We often talk about people who are incarcerated pre-trial, and then they eventually go to trial, and then they're found guilty or they plea or whatever. What we don't talk about often enough, and it happens more often than we know, is that people are put in jail pre-trial, have not been convicted of anything, and when they go to court, they're found innocent. And they've still been there so long that they've lost their job and lost their car and lost their residence. So you could essentially be picked up, put in jail, found innocent, and still end up homeless. And that is ridiculous. In closing, I just want to say real quick, no discussion about pretrial detention could really be complete without the mention of this gentleman here, Khalif Browder. Khalif was just 16 years old when he was arrested for stealing a backpack. He was detained pre-trial and sent to the notorious Rikers Island for 3 years, 2 of which were spent in solitary confinement. Now, mind you, he had not been convicted. After 3 years, Khalif was released without being convicted, and 2 years following his release, being unable to further endure the scars he had carried from the emotional and physical abuse he endured at Rikers, he hung himself. Browder's case and others like it tell us unequivocally that money, bail, and the wrongful imprisonment that too often accompany it must come to an end. Thank you so much. I guess at this time I'll lateral to Alex, and he'll take it from here. Alex?
Hello, guys.
Hey.
And in this part of the presentation, we're basically going to be unpacking, what are our reforms? What is it that we're standing by progressively to de-incentivize the use of cash bail and to move towards more release of people who would ordinarily be detained pre-trial. Next, okay. And Those fall under sort of three categories: procedural safeguards for setting bail, political accountability, changing the overall function and the culture of how we talk about cash bail, and where we're going to be moving as far as what direction we're going to be moving as far as bail reform, and making sure that those officials at the state level especially are held accountable. And also dismantling, downsizing the criminal justice system, ending overall long-term mass incarceration and what it's become. And for our procedural safeguards, the number one thing that we really want to prioritize is release, with minimal to no conditions imposed. Again, we want to make this the whole idea of a pretrial service rather than a pretrial punishment. We want to also have bail determinations being made 48 hours after the arrest, with recorded justification by the judge if there's going to be money bail imposed. But we want to make sure that we keep that time frame to 48 hours so that you as a resident are not spending too much time behind bars that can obviously have a negative impact on the rest of your life, in the case that you are brought in and booked. And we want to prioritize personal recognizance for certain lower level offenses like traffic violation, low level drug possession. And what that basically looks like is once you're confronted and detained, arrested, detained, you've had your bail determination, but because you come from a certain, background, because your financial status might not be the same as like somebody who's in a more privileged position to be able to pay for their release, you're just basically, signing a document promising that you're going to come and show up for your court date. And as far as political accountability, like I mentioned earlier, we want to hold our elected officials accountable, especially local and state actors. We want to monitor the bail setting practices of elected judges. And because overall, there really isn't a whole lot of data collected from different counties in regards to pretrial case information. To assist with establishing pretrial services, we want to make sure that certain information, like basic demographics, conditions of bail, that all of this is basically on the public record for each county, because there's a tremendous lack of information currently. And that would go towards setting pretrial services such as call and text reminders. So if you can imagine, you're let out, and instead of having to pay to show up in court, pay for your presumption of innocence, you have somebody who's just sending you a reminder, like the same thing that if you were to have like a doctor's appointment, a dentist appointment to show up for. That's the kind of pretrial services that we want to provide towards people, so that there isn't a financial burden imposed. And just to give like a brief example of somewhere where this has worked so far is New Jersey has implemented progressive bail reform as far as release, prioritizing pretrial release for low-level offenses, and it's resulted in a 40% decrease in pretrial detainees. And I think go to the next slide. Yeah. And overall, as I said earlier, we want to reduce the scale and the reach of the criminal justice system. Mass incarceration is something that's blown up just to massive proportions. And we really, really want to, chip away any way we can with these policies to get to the the long-term goal of doing away with that, massive sort of beast we've created. And we want to divert resources away from incarceration to also community-based alternatives, such as during the pretrial stage, there's a model called participatory defense. And what that basically looks like is that your friends and your family have more contact with the legal defense team. They're able to vouch for you legally, speak for you in court, give an overall better picture of you as a person when you're coming up for that first trial. And usually the kind of perception that people get is like, well, this is a person that has this charge, this charge, this charge. Well, with the community-based model, we want to show something that's more rounded. And that's a service that works, with families, community, activists, and it also, teaches them how to represent. And I'm going to give it over to Alana for downsizing.
Hello, everyone. Thank you, Alex. You gave an awesome overview of all of the things that we can do, or these are things that these are some of the items that we can put pressure on our elected officials. We want to talk a little bit more about how. So, reduce the scale and reach of the criminal justice system. What does that actually look like for us as individuals who are not policymakers, who are advocates, or just everyday tax-paying people of Ohio? So when we think about this, one, all of these people who work at the jails, who work in county government, all of these people are public officials. So whether they were elected, whether they applied for the job, they are public officials. Our tax dollars pay for their salaries. That means that they have to speak to us. They have to see us. So doing things like scheduling appointments. Sometimes in the beginning, you won't be able to get an appointment with a judge, but you are able to meet with their bailiffs. All of these things are public records. So going on the website, looking at who are the judges who are at the municipal and the county level, and then looking at who are their bailiffs and calling and being diligent and asking, hey, can I meet with you? They have to meet with us because, again, we are the citizens, we live in this state. When we look at diverting resources away from incarceration, it's very important to note that Ohio spends a lot of money on mass incarceration. Back in 2019, DeWine allocated $1.9 billion to be allocated to Ohio's Department of Corrections over a 2-year period. That is a lot of money. He did highlight that some of that money should be used for community residential programs and institutional education services. That is great. It is our job to hold him accountable to that. So writing letters. Right now, we are seeing that we have a very interesting indirect way of getting information to him. So using his 2 p.m. Press conferences that he do every day and sending messages directly to him, directly to the reporters, all of that information is public record as well. Social media is great for that. So a lot of people, ACLU did this a couple weeks ago where they actually had a Twitter store. The more of us that can join when organizations decide to have things like a Twitter storm or a Facebook tell-all or something on Instagram, those are the things that will put pressure on him. We have a chance of having direct access to him because of the pandemic. So when we are also asking for, during this time, for people to be released from prison, this is a great time to say, hey, that $1.9 billion that we are asking, that you have allocated, if you release these people from prison because we know they're dying right now during this COVID pandemic, use some of those resources to make sure that we have temporary housing and drug rehabilitation and treatment set up for these people. Because again, those are our tax dollars. $1.9 billion is a lot of money. He's already said and stated, put in writing that some of that money should be allocated to community outreach and to drug rehabilitation, it is our job to hold him accountable. And the ways that we do that are we join these press conferences, we write him letters, he reads those letters, we see that now. We send emails. If we can't get in touch with him, we talk to his staff. We bug them as much as we can. We have our friends and our neighbors calling and emailing and tweeting him, especially if we have extra time on our hands. And sometimes, even if we don't, it is, right now we are seeing in Cleveland a divestment into our local media. And so we know that that is going that is very harmful, and that for our advocacy groups and for those of us who are in social justice, that is very sad for us. That is also an opportunity. And so I think we have to also start looking at these things as opportunities. We know that our local media, Plain Dealer, is being divested. So we can make op-eds ourselves, and we can write things, and we can disseminate it amongst each other in different groups, so that we are able to put pressure on these people. And we have to ask, when we are downsizing and dismantling, that also resources are given to these people, because we cannot just release people out into the street with no resources, because that is just a setup for them to be, to reoffend, and for them to just end up homeless. So.
Very well said. Thank you, Alana. So we just threw a bunch of information at you at once. So I wanted to summarize real quick before we get into the next couple slides. Consider bail as that front door of mass incarceration. It's bringing people in, it's holding folks who don't have that dollar amount to be released during that critical pre-trial stage. Folks who are being detained or being held pre-trial are not able to readily access their lawyer, are not able to gather discovery or contact witnesses, as Dave and Marva mentioned. They're more likely to plead just to get out of jail, just to go back to their job, go back to their homes, go back to their loved ones. So not having enough money during that stage, not being able to pay that cash bail, could spiral your entire life. And from there, as we know, folks who have felony convictions face a number of barriers, because we haven't built a society that truly allows people to come back out and flourish the way that they should on a systems level. But we also know that there are common sense reforms that can alleviate this. So when we say things like cite and release policies, or things like personal recognizance, that's the front end of the system. So cite and release, that's a police officer writing a ticket for someone who's jaywalking, instead of maybe that encounter escalating and turning into, resisting arrest and then an eventual arrest. When I say something like PR or personal recognizance, all that is signing a sheet or signing a contract that says, I guarantee that I'm going to show up to court during my court date. And the definition of bail is to guarantee someone's appearance in court. So you're still fulfilling, again, that obligation of what bail means. And then some of the other things we described, getting call or text reminders to make sure you get to court. If someone needs conditions like potentially drug treatment or seeing a counselor, making sure those conditions are equitable and fair, and that we're truly divesting resources back into the community, as opposed to building out an even stronger, more intrusive criminal legal system. So before I get into the next phase, I want to, I'll wait for questions for the end and save that time. But the last tactic that I want to talk to you about is what we did last year with Criminal Rule 46. So Criminal Rule 46 establishes the procedure for setting bail. And I wanted to describe this campaign peak for you all because it was a tactic that we employed to change the bail setting procedures. Because a lot of this, as we're seeing, it's structural, it's procedures, it's systems. So the rule, as it stood, gave a lot of deferential authority to not only the current bail setting practices with things like bond schedules, but also just judges. Judges have mass authority to release folks, set bail conditions, approve bail recommendations, and assign them. So this rule really, gave a lot of deferential treatment to judges and sort of let them run the show. So we have been submitting comments to actually change that administrative rule, change the actual procedure of that rule. What are some of the things that we said in our amendments? We asked for a single definition of bail, because in the Ohio Revised Code, there are multiple definitions of bail, some of which are really comical, like bail is actually cattle, and some 1850s bail definitions that never managed to get out. We also asked for conditions to not cost a defendant. So let's say somebody is being released pre-trial. Again, they haven't been convicted of a crime, but they're still on the hook for paying things like GPS monitors or paying for drug tests. We asked for those things to be free. And we made a number of recommendations to make the rule more constitutionally sound and respect due process. So we submitted a couple versions of that amendment. It kind of goes through a very administrative process. And the last submission, we had over 40 organizations, including the United Unitarian Justice Ohio, sign on in support of the progressive amendments that we made. So I want us all to think about Criminal Rule 46 as almost like the bones of bail reform, the structure and the actual procedure, but it wasn't enough. We found out that the court didn't take our comments, but we now know that the court can see that there's a public groundswell of individuals and organizations who want to see true bail reform. So I consider this a huge mobilization victory, and it's really declaring that, you know, the state of Ohio is ready, it's primed for bail reform. And this is where we go, especially after COVID. So before I leave you, I want to lift a couple links. If you want to stay in contact with the campaign, please click the link for the volunteer sign up, which will just lead you into a Google form where you can put your name and email and address. If you know somebody who's in prison right now or potentially jail and they want to report any issues, I want to lift our COVID-19 email hotline. We have folks who are reviewing the entries into the submissions to that hotline nearly daily. We had a couple action alerts, again, urging DeWine to mass release folks as much as he can. And if you want to learn more specifically about bail and its intersections in juvenile justice and immigration, I highly recommend our bail reform podcast, The Steep Road to Freedom, available on all podcast platforms. So I'm going to stop sharing and open the Q&A.
We do have several questions in the chat already, which is wonderful. One asks, what percentage of charges actually go to trial? And why do so many decide to do a plea deal?
So before I answer these questions, I want to preface that I'm not a lawyer, and we can definitely set up another legal-specific webinar just to make sure we have all our bases covered. From the experiences that I've seen with people from the ground, a lot of folks plead just to finalize the situation, get themselves out of jail. 90% of cases are actually resolved through plea deal, not only because of the convenience, but because you know, the scare tactic of it all. Like, you're being held, you could have been held pre-trial for a month or so. You don't know what's going to happen if you take your case to trial, and people end up pleading as a way to end the situation. There's a lot that goes on emotionally to actually take a case to trial, and then also know that depending on how it goes, it could turn out horribly. So a lot of folks plea, or they're presented with a lesser charge based on the prosecutor. But there are a number of reasons, but just know, you know, the vast majority of folks take those pleas.
Melissa, can I just add something? That when you say they take a plea to get out of jail, a lot of times they're taking a plea to get out of jail, but to go to prison, right?
Yeah, excellent point. So jails are local holding facilities, again, operated by your local county or district. So you're only in there if you're being held pre-trial. If you're waiting for a transfer because you're serving the rest of your sentence in a state facility or a state prison, or you're there during this transitional phase, or serving like short-term sentences for like misdemeanors. But a lot of folks are just taking pleas just to get out.
May I ask something?
Yes, Martha.
Hello?
Yeah, we can hear
Hi. Okay. Now, let me say this. This is a good program. You explained everything very clearly. For some of us, we knew the things you were telling us. We already knew the horrors of the whole bail system. We understand it. Now, I was hoping to hear on this show, what is the ACLU doing? What are they organizing as an attack on this terrible system that maybe I could help with or something? I mean, I would write letters to politicians and, you know, jail holders, jail people, and all like that, if others were doing the same thing, so that it would have some effect.
That's yeah, thank you. That's an excellent point, and thank you for lifting that that question. So we're doing a couple things. We're organizing a base of folks within all of the counties in Ohio, specifically focusing on the major Cs, Cuyahoga County, Cincinnati, and Columbus. We're getting those folks together to start doing some of those high pressure actions like letter writing campaigns, phone calls. Criminal Rule 46, because that was such a long extended process, was one of our major peaks because we had an opportunity to change the structure of bail if this was successful. So we had UU Joe, the Ohio Organizing Collaborative, all these organizations sign on in support. And that was in some ways successful on a mobilization front, and in other ways not enough to actually bring us the change we need. But right now, what we need is mobilized people ready to take action when that comes.
Yeah.
Should we also tell Martha about the letter? Isn't there a letter that people can sign on to? A letter to Governor DeWine?
Yeah.
Online, and do we still have our letter about funding the pretrial detention electronic monitoring business?
Yeah, so we still have an action item that's on the link, and that is a petition urging Governor DeWine to release folks.
Where is that? How do you find it?
Yes, I think this is at the top of, if you just copy and paste the first link that I sent, the HTTPS.
All right.
And for folks in Cuyahoga County who want to get involved, we have a local petition pressuring some local actors to erase or eliminate the cost of GPS monitors, because folks who are getting released, but they still have to pay for this GPS monitor, they haven't been formally convicted of a crime, they're still on the hook for that, and it's still extracting money from low-income people. So if you're in Cuyahoga County, again, you can click that petition link and sign.
I'm in Hamilton County. We have a huge jail, a terrible and huge jail. But you may know, I hope you know, that we're going to elect, because Charmaine McGuffey, a wonderful woman who ran the jail at one point very well, changing everything about it. She just defeated in a Democratic primary Jim Neal, who has been running the jail since he ran her out. Now, that is a big step for us in Hamilton County.
I also recommend folks sign the Google form so we can better directly connect you with folks in the region who are working. I think the really exciting but also difficult thing about bail reform is you have local actors like your sheriffs and your county executives and your local judges, and then you also have these statewide actors. So we have to be pressuring both at all times. And the Google form would be a good way to target who exactly you should be talking to and how we move. And my colleague Greer is on here working in Cincinnati, so I'm excited to connect you both.
Right to the governor. I would be happy to do that again if others, if we have a mass writing, you know.
And I'm sharing now what the Google form looks like at the link that Melekte already gave us, and also what the website looks like with more information about how to take action.
I had a question that I wanted to toss out there, and it has to do with why is it that other states seem to do more, such as Harris County in Texas. In Texas, I mean, you know, these individuals, the individuals that were incarcerated, worked very hard to file a lawsuit against the system at large as it relates to bail reform, and eventually they were very successful. So, you know, why is it that it seems other states are doing a little more than what we are, you know, kind of doing here in Ohio? Anyone?
I personally think just from even speaking to people at other states who've had a lot of success. One, I think a lot of states have been very good at getting people who were directly impacted together and organizing them in a large enough group where that when a class action lawsuit is presented, you have to show damages. And so one of the things I think that we're learning here in Ohio, because Ohio has a very conservative history, a lot of times when we're talking to elected officials, they're asking like, who are those directly impacted people? And so a lot of us organizers are learning when it comes to mass incarceration, we are learning to go and get those people who are just coming straight out and building up their power so that we can present a class action lawsuit, because anytime we present those, a judge wants to see damages. And oftentimes us as community activists, if we haven't been directly impacted, we can't speak to what those damages are.
Right.
And I think it takes a lot of skill set. It takes a lot of trust building. It takes a lot of us going into the community and building relationships and also mitigating harm. I think another thing is in Ohio, we have a lot of sometimes violence against women and drug addiction, and that comes with a stigma. And I don't think a lot of us have done a good enough job as community members of explaining that those people still need help too.
Right, yeah.
And explaining like, hey, there are resources and we need to be connecting people to resources, not just incarcerating. So I think there's some stigma, there's some politics. But I think the more of us that are able to build relationships with people and to show how these people also can be rehabilitated, and then use teaching them and building up their skill set so that we can actually present a lawsuit, I think that is what's going to really push us more.
Right.
And I think it's just been probably over the last year or so that we've noticed like, oh, we need to shift. Like, it's great that we're out here, but why don't we actually go get some of these people who have actually been formerly incarcerated and have them lead this work, because their voice will always shine more than ours.
Right.
I completely agree. And sorry.
I'm just going to add one more thing. Like, that's the common thing that you see in other states. Like, there's always an emphasis on like the personal narrative. Like, you go on websites, you always have like a personal story, like a testimony. You get to see a face, you know, in just like Dave and Marva were talking about earlier with the individual case. What was the last? Bolden?
Browder?
Yeah, Browder.
And Robert Starks.
And Robert
Yeah.
Starks.
So building up that kind of narrative storytelling is what helps to, you know, put a face on it. So that's the model that we're going by, building up.
Just out of curiosity, is it that in Ohio we have people that are less willing to step forward, or it is just simply a matter of having not built those relationships?
It's both.
It's both. I know personally, like Zaria Davis and all of the work, she's in Hamilton County, and she's an African-American national leader around formerly incarcerated Black women.
Okay.
And she works with several organizations that actually take people who are formerly incarcerated through an advocacy program for a year-long program. I think it's pre-trial justice Institute. I will drop the link in here and you guys can look at it. I think a lot of it is relationship building. Yeah. I don't think we do a good enough job of relationship building, honestly. I think we have to get out of our comfort zones in a lot of ways and really build those relationships so that people are not going to be afraid. Because the reason people are afraid is usually it's the backlash. It is they're afraid of retaliation. But if they know they have a community behind them that is going to support them, then they are more willing to take the risk. And so I think that that comes with some of us who are privileged to do this work, whether we get paid for it, whether we have more privilege in volunteering. Because I think we also have a lot of working class people. And sometimes we think people don't want to get involved, but if I'm working multiple jobs, if I have a family, I do not necessarily have the time, the resources, nor the energy to get involved in a social movement. So it comes up with us to figuring out, okay, I want you here. How can I support you? Maybe it is at every in-person meeting, we make sure we provide childcare, and we have a meal, and we have someone who is a tutor to help this young mother. Maybe it is, yes, I want this formerly incarcerated man here, but I understand that he needs a job right now. He also is under community control, and so he's not allowed to leave these certain places. So maybe my organization is able to get him a Google Chrome laptop so that he can Zoom in.
Right,
It is
right.
us going above and beyond. It's us using our privilege and our organizational capacity and our resources to really make sure these people are able to come to the table, want to be at the table, and all of that starts with relationship building.
Right. And
Also,
I'm sorry.
oh,
go ahead.
sorry.
No, I just wanted to add that you're absolutely correct, because Robert Starks III, he came to us as an organization at the time. His need was great. You know, no one is looking at a system that just plucks you off the street and incarcerates you and you know, keeps you in a jail system for 30 days, hoping you'll plead to something that you didn't do. Had he not come to the organizations, you know, it's a scary thought what might have become of Mr. Starks and his children when we have a system that refuses to have checks and balances. So yes, you know, organizations and individuals and programs like this is so very important to reach out into the community to let them know, you know, we all exist. ACLU exists. And all the other, you know, organizations out there, because people are not aware. You know, we're just so blessed to be a part of the community, you know, that was active and actually moving agendas forward to ensure people are not incarcerated wrongly, or that they have attorneys. You know, there were a few attorneys that we were working with during that time, you know, to make sure people had proper legal counsel. But, you know, and Dave, which he doesn't talk about, he's a former union president. So, you know, we understand it takes all of us, you know, it's not a color thing. We all need to band together.
Well, it shouldn't be a color thing, but it is.
Yeah.
Yeah, I think also if you want to look at the broader picture, some of those states that have had really significant reforms, California, New Jersey, New York, they have really substantial politically liberal populations to sort of stand up for those things.
Yeah.
And
So
we
Ohio
don't
tends
do that
to.
here as much, and that's my reason for bringing that up is just to emphasize how much electoral politics has to do with this, that in order for us to get to a point where we have a state legislature that isn't so just vastly dominated by conservatives, we really need to do something about gerrymandering.
And I totally agree, and I wanted to bring up Ohio's political landscape. So in the 2017-2018 legislature, 1 in every 8 bills created new laws or expanded the scope of existing laws. So we have lawmakers that are passing laws that are currently extending the time that people have who are already serving, or creating new crimes, new definitions of crimes in the state of Ohio. So when we say, you know, our jails are at 127% capacity, this is why. We also need to be clear about what gets passed and what doesn't. So for every 700 bills that get introduced at the Ohio legislature, only 21 become law. So we just have to be very strategic about pushing criminal justice reform, really dismantling some of the common messages we hear around tough on crime policies. We're still electing tough on crime politicians. So, you know, that synergy between electing progressive candidates, making sure that they know that they're Ohioans who care about things like bill reform and ending gerrymandering and some of these progressive issues, and then holding everybody accountable through issue-based campaigns. I mean, that is how bail is going to be accomplished, because even through a lawsuit alone, you don't get full bail reform. Even through a law with that isn't, you know, we're not holding judges accountable, even through a law, we won't get full bail reform. We need all of the pieces working together in cohesion, checking on one another.
Melekte, another question came up. Is the ACLU doing any work now to address court costs and the problem of debt that creates?
We don't have any current campaigns around court costs. We published a really amazing report on debtors' prisons in 2016 that I recommend people look at. We also published a report around mayor's courts and the fees, fines, and discriminatory policing practices that lead to people finding themselves in mayor's court. We're focusing on high impact campaigns. So bail is a high impact broad issue-based campaign that begins to address things like court fees and parole. And I consider it kind of the gateway into all of these other campaigns.
This is Lori Albright. One of the reasons that I think the time is so important right now to press demands and accountability regarding bail reform and other things regarding the justice system is that at least the people in Cuyahoga County, both administration officials and judges, have been very clear that one of the driving forces why they don't want to release people from jail is because it would look bad if that person then was in the community and did something, and that's like number one fear. So they're just like, I just have to keep doing what I'm doing, keeping people in jail so I don't look bad. The reason that we reduced by 50% the jail population in Cuyahoga County is because the people in charge met with the medical director at Metro, who said, COVID is coming and people are going to die unless you do something. And they happened to have a judge meeting the next day, and they had the good sense to actually listen to the medical director, and they got busy and really made a change and made some big moves. So it was, oh my gosh, I better do something or I'm going to look bad in the community because people are going to die. You know, so once this COVID stuff goes away, it's likely to go back to, oh, I can't release anybody because it's going to look bad if something happens. If we can keep the pressure on, it's going to look bad now if you don't do this, if we can establish a pattern that's different from what's been, I'm very excited about that possibility.
Yeah, it's really interesting about that because most of the individuals that are incarcerated are nonviolent, as they call nonviolent offenders. So it's interesting how the process looks at one person who might come out into the community and do something violent because of those tendencies, as opposed to the many people who should be released who are nonviolent, who are not there, traffic tickets and things of, you know, of that nature. But
that excuse, basically what it does is protects the system as it is, because it is a money system. Yeah. And so it's easy to say, well, if we release this guy, this and that might happen, because that excuse protects the system. And that's what we've got to change, right, is the idea that me looking bad is more important than you dying.
Yep, and a system that will release this person who's charged with a heavy murder charge, as opposed to someone who's just in there for a traffic ticket. So why would you release, not release the latter person? So it's, you know, it's designed to make bail reform look bad.
And if you don't change the racial aspect of this thing, what you're going to continue to have is the same thing. Poor black people in there for nonviolent offenses. You got white people being bailed out for violent offenses. Mm-hmm. And you're going to continue to have this thing on and on, do the same thing, because we got to face it. This is a racially oriented system. And until we can change the core of what goes on there, we're not going to really change this system as a whole, because it's designed for the people who have money. And most of those people that have money are not poor and black. It's just basically the way it is. That's the reality of the system.
Yeah.
Yeah. Overall, we don't want money to be the main deciding factor in guilt or innocence, because as far as like the racial component, we know where the money's going and where it's not going. Unfortunate, but it's a sad fact.
It is.
But we need to isolate these core issues and develop a systemic plan and an action that really works. And part of that, majority of that lays with our judiciaries, because they're the ones that are adjudicating these cases. And
the prosecutors.
And the prosecutors.
You can't rule out the prosecutors. Yeah. If the prosecutors don't bring these crazy cases and don't withhold evidence, and don't do all of these other crazy things prosecutors do, then there's nobody in front of this judge to incarcerate.
Right, and bullying people to take these. So, you know, it's a process, but at least we're starting. We're doing something. And
yeah. I'd like to, oh, sorry, Eileen.
I just wanted to make one point, is that you guys are talking about how judges and prosecutors, well, all of those people are elected. And so it seems to me that, you know, one really critical part of the puzzle is organizing to have people express how they want their communities to be policed and how they want their communities to be, to interact with prosecutors and judges, and that how do they feel about mass incarceration? And
well, I agree with you entirely about that. Yes, we've got to organize ourselves to do those things together and not depending over much on the people who have suffered from this system. We need some that we can put forth and show what can happen to people.
Right.
But we who are not incarcerated or afraid of being incarcerated anytime soon have got to act together.
Right. Yeah.
Privileged people, let's put it that way, who can act together.
amen.
And try to embarrass the governor and the whole GOP of the state, try to embarrass them. It takes a lot to embarrass them.
So what
And it is possible too for hope here, because Greer had a wonderful comment of hope. She said that Greene County's great victory today in defeating the new jail tax shows that it is possible. Build these campaigns, coalition, even in less progressive places. So this is something we can work with.
Yeah.
And we need to stop looking at people of color or someone who makes less than you as someone who's lesser. Yes. And because we all, I believe, want the same things. We want a clean environment. We want to be able to live and move freely and participate in.
Feel that we're safe and our kids are safe.
Yeah, like Dave just said, you know, feel safe, that our kids are safe.
Oh, absolutely, absolutely.
Yeah.
And then one more thing I'd like to say, and on top of, and it kind of dovetails from what Eileen was talking about. The other thing that we have to actually do a better job of is getting candidates to run against these people who need to be put out of office.
Yeah, yeah.
And that's what we just don't do a good enough job of. We don't support people to get these clowns. I mean, it's just like the prosecutor, he just ran unopposed. Many of these judges run unopposed. And as long as that keeps happening, it doesn't matter because they're going to get voted back in.
In Hamilton County, we elected a wonderful new prosecutor, person of color, John Rooker, and a new, as I said, Charmaine McGuffey, who knows how to run a fair jail. We did it. We got her.
All right.
I mean, she still has to run in November against the Republican, but the Republican won't have a chance.
It is possible.
Yeah.
It is possible.
It is. That's why the landmark case in Harris County, you know, please Google it and take a look at that. That's to me, I find that to be one of the most, watershed cases and
thank God for some victory.
It's hope because it's in a place like Texas.
Yeah, absolutely.
So before we head off,
Melekte, yeah.
So before we head off, thank you, Joan. Thank you so much for being part of this discussion and this lively Q&A. This is exactly how I like to organize, and thank you for giving me a slice of that. But we are right now building a statewide grassroots movement to do exactly this. Contact our elected officials and start building a dialogue. We care about bail reform. We want you to implement bail reform on a local as well as a statewide level. And we want to lead and have folks who've been directly impacted by this issue lead and shape our organizing. So that is what the ACLU is doing right now. We're still keeping tabs on what's going on with Criminal Rule 46, which has been our big mobilization peak up to this point. But there's still so much to do. And all Criminal Rule 46 showed to us is that it's really going to take people power to move this forward, to make this possible, because the Constitution is on our side, the fiscal analysis is on our side. It saves us so much money if we're not incarcerating these people pre-trial, even though I don't like to lead with that. And we're all ready to transform our system and what it looks like and divest from it. So I strongly encourage you to fill out the Google form, to listen to A Steep Road to Freedom, because we get into issues like how does juvenile justice and bail intersect? We talk about the Harris County case. case. We contacted folks who were directly impacted, and they told their story in a narrative that they wanted to share. So there are a couple options for you to study up and sort of get to where we need to be to start having those conversations with elected officials. Thank you all. Thank you all to my incredible volunteers. Always inspired and delighted to see you. And thank you again, Joan.
This is absolutely wonderful. And as we close, I want to let you guys know that those of you who are registered, I have your email. I will send you a letter that has all the links that we have mentioned during this evening, because I know some of them were pretty long and you might not have caught them. So we'll send the links. Also, I'll send you a link to this video, this recording that we're making, and I will be posting this to Facebook as soon as I'm able to do the technological wizardry on it. So it'll probably be tomorrow morning. And as we close then tonight, I'd like to leave us with just another thought that we can take with us as we move into this this time of action that the times are calling us to. And this is a quote by Howard Thurman. And Howard Thurman, the great theologian, said, "Do not be silent. Do not be silent, for there is no limit to the power that may be released through you." So I want to leave you all with that thought tonight. And thank you as well.
Thank you.
Thank